Welcome to the Consumer Finance Podcast. I'm Chris Willis, the co-leader of Troutman Pepper Locke's Consumer Financial Services regulatory practice. And today we're going to be talking about mock jury exercises, what they are and how they can be used in consumer financial services litigation. But before we jump into that topic, let me remind you to visit and subscribe to our blogs, troutmanfinancialservices.com and consumerfinancialserviceslawmonitor.com. And don't forget about all of our other podcasts. We have the FCRA Focus, all about credit reporting, the Crypto Exchange, which is all about crypto and digital assets. We have Unauthorized Access, which is our privacy and data security podcast, Payments Pros, all about the payments industry, and our auto finance podcast called Moving the Metal. All of those are available on all popular podcast platforms. And if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. Now, as I said, today we're going to be talking about a very interesting topic, which is how and why you'd use a mock jury exercise in consumer financial services litigation. And joining me to talk about that are three of my partners, Matt Hansen and Jason Manning, who are partners in our consumer financial services group, and Michael Lacy, who's the practice group leader of our consumer financial services group. So, gentlemen, thanks for joining me on the podcast today.
Thank you, Chris. It's great to be here.
Happy to be here. Good to see you.
Good to see you again, Chris.
All right, well, let's jump into it. So just for starters, some people may not even know about this, particularly if they haven't done a lot of litigation in the past. So what are mock jury exercises? What is that?
There's a wide range of this, but anytime you're taking a case to trial in front of a jury, there's a very high degree of uncertainty. Who's going to be on the panel? How are they going to think about your case? How are they going to receive the information? Will they understand it? So a mock jury is essentially designed to do a practice run. Call it a preseason game, if you will. Let's test our theories. Let's help clarify the evidence. Let's see what the jury thinks and feels in response. And it could be informal. We're talking, let's just do openings, and we'll have 5 people that are non-lawyers that are just going to listen to it and give us feedback. Or it could be very sophisticated and you actually stage a trial. You go to a courtroom, you got a judge up there, you've got a jury of 12, and you're going to go through the first half of the plaintiff case. I mean, it can be as sophisticated as having jurors wear biometric watches with real-time feedback of software running, accumulating that data as it goes and somebody's watching it. It just depends on what you want to spend.
That's very interesting. Thanks, Jason. Matt, let me turn to you. Why would you do a mock jury exercise? Jason alluded to the uncertainty of trying a case to a jury, but can you give the audience a little more color about why a client and its legal team would choose to do one of these?
Yeah, absolutely. That's a great question, Chris. I think really the why, there's a few things that come to mind. One, you want to test the themes in your case. As you're getting ready to try a case to a jury, you're thinking a lot about the themes and how those themes will be presented through which witnesses and the evidence that's there in the case. And so a mock jury exercise can be very helpful to understand how well your case resonates with the jury. And also it's important you're testing your opponent's case too, right? And that's a very important aspect of this. To get good feedback, you have to be able to present both cases in an equal manner. And you want to do just as good a job presenting the other side's case as you are your case. It's also helpful to identify the jurors that you would like to have on your jury pool. And the flip side of that, the jurors that you would like to avoid. So through this exercise, you're seeing how various jurors react to different aspects of your case. You can determine what type of individuals, when these tests are put together, you'll get a lot of demographic information, a lot of just background information about the juror. And you'll find out which jurors your message resonates with and which ones are resistant to your message. And that will be very helpful in the jury selection process.
Okay.
Let me jump in here, Chris. A couple other things. I mean, usually, at least in my experience, when you're at the mock jury stage, you clearly appreciate that there's a risk of an adverse liability finding, which you're trying to test. Again, testing those themes, those witnesses, as Matt and Jason alluded to. But you're also trying to test or trying to get a handle on how much exposure are we really talking about? And so these mock jury exercises usually include some type of, obviously, liability finding, but also if there's a finding by the mock jury of liability on behalf of your client, how much is the case worth? And that's where things get quite interesting, watching these mock juries discuss damages and as some of our clients know, some portions of the public have definite thoughts about financial institutions and how they're perceived. And that really comes into play when you participate in these mock jury exercises.
Michael, that's a perfect segue into the next question I was going to ask. You mentioned, it's for a case where you anticipate some possibility of an adverse result. What kind of cases would a client and legal team do a mock jury exercise in? I mean, obviously, it's not every case. What makes a case special enough to warrant that exercise?
Sure. In my experience, there are two components that don't necessarily have to both be present, but usually when both are present, they're the best candidate. One is, you have a particularly difficult set of facts in real time. A lot of times you're talking about, in our world, a foreclosure of a home, which obviously has an incredible personal sentiment to it. Also, you're in a jurisdiction that historically you've seen jury awards that are pretty significant, and that that's a possibility, and you normally combine that with your opposing counsel. Is this opposing counsel someone who tries cases, has gotten significant jury verdicts? In my experience, that's really the sweet spot in terms of when you really need to think about whether to do a mock jury exercise.
Okay, makes sense. So, Jason and Matt, let me turn to you and ask you kind of another detailed question. When in the timeline of a case does it make sense to do a mock jury exercise if you think it's a good idea to do? Is it near the beginning? Is it in the middle of discovery? Is it a week before trial? When would you do it?
Yeah, I think the timing is very important, Chris. And like a lot of things, it's probably going to vary case to case. But I think you have to have been far enough into discovery that you have a good grasp on what the facts are. You know what the case is going to be. As has been alluded to, it's very expensive to do a mock jury exercise, or can be very expensive. And so you'd want to wait to incur those costs until you feel fairly confident you're going to be trying this case to a jury. And so you want to make sure you're past that threshold. But then once you get to the point where you think, this really isn't a summary judgment case, I think we're going to be in front of a jury, and this looks like we're not going to be able to resolve it. We need to start thinking about investing the money in this. You want to give yourself as much runway to learn what you can from it and still put a case together. You use the example of a week before trial. That wouldn't be very effective. You want to give yourself enough time to be able to adapt your case and work with your witnesses, put together, emphasize the themes that resonate well in your mock jury exercise.
Makes sense.
Yeah, and I'll just add, Chris, part of the answer to your question is, what does the scheduling order allow? Some courts, I'm in Richmond, and of course we've got the rocket docket. So trying to fit in a mock jury exercise can be challenging. Other courts, where you have more time in between the close of discovery and the actual trial, obviously that makes it more amenable to doing this. And I hope folks appreciate this is different than when you're getting ready for an appellate argument and you might want to mock that argument. That record is static. The briefs are in. You know what the other side is going to say. You've said, obviously you have the underlying decision from which the appeal comes. Here, you're really doing it on the fly as evidence. The depositions are taken and the documents are being produced and the like. And that's why Jason alluded to earlier, these mock jury exercises can really take as many different forms as the imagination has, right? From anywhere just doing opening statements to plain deposition testimony to mock juries to doing closing statements or something in between.
Yeah, and that I think is a great way to lead into our next question. I was actually going to ask Jason, how do these mock jury exercises work? How do you go about just putting one together? I mean, are there like consultants or companies that help? How does it work?
It really depends on what you want to spend. The truth of the matter is there's a whole range of this. Most of the ones that I've done, my client didn't want to go full court. We're going to retain a jury consultant and do a full mock jury. It's usually a hybrid. So for example, it was opening and the key witness. And that's what we presented, where we had someone play the role of opposing counsel and do their opening as well. So we're both testing our themes. We're framing it for the jury. And then the key witness, who we both sides agree, the testimony is going to turn on the credibility of the witness as to it comes down to who does the jury like and who do they believe? And it's invaluable to test that on a disinterested, diverse demographic group that are not lawyers, right? We always talk about our cases internally amongst the team, and we're always brainstorming those things, but we're all lawyers, right? So it's nice to have a non-lawyer's perspective. And usually We cut it off after the openings and we do one witness, opening and cross, and then we pause. And I've found that the jury consultant piece of it almost always adds value. The jury consultant has done these professionally more than almost any attorney has tried cases. So they have a lot more experience in identifying commonality amongst juror types and themes that are likely going to resonate with those juror types, which is really important so that you can take that with you when you're actually at the trial picking the jury, which is always a harrowing experience.
I'm sure it is. Well, I don't think this episode would be complete without talking about some war stories. And I'd love some of you to share those. What are some things that have happened that you've learned in mock jury exercises that you've done? Michael, do you mind if I start with you?
Sure. A couple come to mind. I did a mock jury exercise during the COVID time, and the mock jurors actually were in their homes. And so it was quite interesting to see they weren't together physically. So they had to communicate over Zoom or whatever platform they were using. And it was definitely interesting to see how they communicated with each other, which wasn't too terribly different than the ones I've done where they've been physically together, although they're much more comfortable in their own surroundings. We had, animals and other pets, going through the screenings and whatnot. That was interesting. The other thing I'd say, one of the best times I did a mock jury exercise, and we were partnering with a local counsel from that particular jurisdiction. Their lead lawyer got the chance to play opposing counsel, and he really played that opposing counsel to a T. And it was really fun to watch. I mean, I wouldn't say it's more fun to play opposing counsel, but you let it loose when you're playing opposing counsel, and it actually helps you learn more about your case, as you think about what they're going to do and the buttons they're going to try to press. So the last story I'd give is we did one where we had two panels that we were watching simultaneously. They were on the screen, and we had headsets that we could toggle between the two panels. And to listen to them talk about how much money they would award if they were to find the client liable was really fascinating. As folks who are listening probably know or may surmise, these damage awards aren't necessarily tethered to the evidence all the time. It's sort of like, what do we think is right? It's always very interesting to hear about mock juries talk about damage awards. When you try to bring in an economist or some other rational thought about what damages should be if we're found liable, they don't necessarily follow that logic.
I'm sure it's quite an experience to watch that deliberation happen. Matt, Jason, do you have any stories you'd like to share?
Yeah, I'm thinking as we're going through this, I'm remembering a mock jury exercise I did several years ago. And this was in a case where we were getting fairly close to trial. We'd really developed our case well. We had a really good understanding of what case the plaintiffs were going to present. And we wanted to fine tune our message, make sure we had our message right. But also the client was very interested in this result from a settlement standpoint. The client, our in-house attorney and client, was having conversations with all the higher ups in the company, and they were trying to make a decision about whether they wanted to really try this lawsuit or whether they were going to settle it. And we set the mock jury exercise up in a way so that we had 4 separate panels, and we presented our case, and then we listened to the 4 panels deliberate, which is, like I said, it's always a fascinating process, see what they latch onto and what they do. And there 2 panels went as far as they could for the plaintiff, and 2 panels were completely on our side, right? So here's the client trying to decide what does that mean from a settlement perspective? What can I take from this? We were able to recognize it's probably not a split the baby type of case. This case, our defense was going to resonate really well with some jurors, and it wasn't going to resonate well with other jurors. And it was going to be higher risk and probably an outcome kind of on the outside tails of the range of possibilities. But we were able to really analyze who those jurors were and learn a lot about the jurors that would resonate with our case. And ultimately, to the client's credit, decided that they were willing to try the lawsuit. And so we went ahead and tried it. We were able to use the data we got from that exercise in our jury selection and get a really strong jury. And we ended up with a total defense verdict, no liability and no damages.
And I assume, Matt, you thought that the mock jury exercises that you had done helped you get to that result.
Oh, yeah, absolutely. We learned a lot of small, nuanced, subtle things about how to present the case and then the type of jurors we wanted on our jury.
Yeah, absolutely. Jason, how about you?
Yeah, the one that comes to mind for me is a particular relatively complex piece of evidence. We weren't sure how the jury would understand it. And so we wanted to present it in a couple of different ways to see which one provided the most clarity to the jurors, and not just clarity, but that they would attach value to it or not. And the practice with different panels enabled us to, as Matt and Mike were alluding to, choose the one that worked the best. To me, that's the greatest value of this, where you're presenting it to multiple audiences in a controlled environment such that you can measure the feedback and adjust your approach accordingly.
Makes sense. Well, gentlemen, this has been a really great conversation, and I think it really showcases the special considerations associated with mock jury exercises and the fact that we have such a great deal of experience with them in the large, complex cases that we might take to trial in our litigation team. So thank you all for joining me for the podcast today. And of course, thanks to our audience for listening as well. Don't forget to visit and subscribe to our blogs, consumerfinancialserviceslawmonitor.com and troutmanfinancialservices.com. And while you're at it, why not visit us on the web at troutman.com and add yourself to our Consumer Financial Services email list. That way we can send you copies of the alerts and advisories that we sometimes send out, as well as invitations to our industry-only webinars that we hold from time to time. And of course, stay tuned for a great new episode of this podcast every Thursday afternoon. Thank you all for listening.
Copyright Troutman Pepper Locke, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper Locke. If you have any questions, please contact us at troutman.com.